So I will discuss about the case which was delivered in 2023, and the name of the case is Messrs Rubber Industries Pvt Limited versus Amit Chand Mitra. The case is related to Section 3 Clause B of SRA and Section 49 of Registration Act. Section 3 Clause B of SRA says that the remedies provided in the SRA will not affect the Registration Act. That is, the remedies, that is, if any document requires registration under the compulsory registration under the Registration Act, and if it is not registered, then the remedy under the SRA will not be provided. Okay. And Section 49 of Registration Act deals with any document which require compulsory registration, which is the list of documents that require compulsory registration is provided in Section 17 of Registration Act. So if there is any document which require compulsory document under Section 17, and if it is not registered and Section 17 is not complied, then what will be the consequences? The property is not affected, that is, the person who has transferred the property and has not made the registration, the person will remain the owner and the property is not transferred. Secondly, such unregistered document cannot be given in evidence. However, there is a proviso to Section 49 which talks about the exception. Such unregistered document can be used in a suit of a specific performance. So if A has transferred his property to B, which is immovable property that requires compulsory registration, and if it is that not registered, so that document cannot be given in evidence. However, if B files a suit of a specific performance against A, then such document can be used in evidence. Secondly, if there is any collateral transaction between A and B, and then the document which was not registered, that can be used in evidence. Okay, so the facts of the case was that A was the owner of the property and she gave her property in tenancy to B for 5 years. After 5 years, she gave notice to B to vacate the property. As per Section 106 of TPA, which says that if the property which is given on lease is being used for agriculture or manufacturing purposes, then minimum notice of 6 months to be given. Okay, and if the property is being used for any other purpose, for example for living on tenant or any other purpose, and then the notice of 15 days is to be given. So in this case, the owner thought that the property is not being used for agriculture and not for neither for manufacturing purpose, and it is being used for residence or other purpose. So she gave the notice of 15 days, but B objected. B said that I'm using the property for manufacturing purpose, so the tenancy will only terminate if 6 months notice is given. So the question before the court was, what is the nature of the property, whether it is the property that is being used for agriculture or manufacturing purposes, or whether the property is being used for any other purpose such as residence. So the issue before the court was that the unregistered document, because the lease was of immovable property and it was beyond 1 year, so that requires compulsory registration, but it was not registered. So the consequence will be 49 will apply, that is, the unregistered document, the lease agreement between the A and B, cannot be given in evidence. Okay, so the question before but it can be used in evidence for the purpose of collateral transaction. So the question before the court was, the issue before the court was that this document, which is unregistered tenancy document, can this be used as collateral transaction to prove the nature of tenancy. Okay, so the court said that any property which is transferred through lease and it is unregistered, even though it required compulsory registered, it can be used in evidence if, as collateral transaction, because as per main provision of section 49 it cannot be used as evidence but can be used in evidence to prove the collateral transaction. If the issue is not the main term of lease and it is not the primary issue before the court. The court meant that ki to know whether the property which was transferred is being used for manufacturing agriculture property or any other purpose. For that, such unregistered document by way of section 49 cannot be used, but to know the nature, such document can be used if if the issue before the court is not if the primary issue before the court is not to know the nature of the document. So in this case, as we know, the main issue was to know the nature of the document, whether it is being used for agricultural or manufacturing purposes, for which minimum notice of 6 months has to be given, or whether it is being for any other purposes for which minimum 15 days notice has to be given. So since it was the primary issue before the court, such document cannot be used as collateral to prove the evidence of collateral transaction. Okay, so this was the case.